Okay. Good afternoon, everybody, and welcome to episode 19, I believe, of the 20-minute talk produced by Commercial Collection Agencies of America. I'm very happy to see so many people, and we have a very interesting topic. To introduce today's speaker, I am glad to have Alex Rosen, CCA of A president, with me so he can do the introduction. Alex, I'll turn it over to you.
Thank you, Annette. I'm pleased to introduce Austin Smith. Austin's an associate at Taroff and Taitz, specializing in commercial debt collection. And prior to joining Taroff and Taitz, Austin ran his own small firm that specialized in consumer class actions. As part of his practice, Austin successfully overturned 20 years of case law and established new precedent at three federal circuit courts of appeals that a certain category of private student loans were dischargeable in bankruptcy. Mr. Smith is a member of the Suffolk County Bar Association and is on the advisory board of Upself, a tech non-for-profit which provides free bankruptcy services to low-income individuals. In his spare time, he competes in triathlons, writes fiction, and produces a podcast on Greek tragedy. Austin, take it away.
Thank you, Alex. Nice to meet you, everybody. Thanks for showing up. We're going to talk today about involuntary bankruptcy, which is, as we'll sort of get into, not a very frequently used remedy these days. But I think it's an important one. It can be a very useful one, especially when you get to the end of your efforts and it seems like there's sort of nothing left to do. In certain cases, involuntary bankruptcy can be sort of the solution. There's a lot of law in this. I'll try not to be too much of a nerd about it, but just to sort of give you a grounding in sort of how it all works, we're going to go through some, a fair amount of the law. Let me see here. So, I want to, sorry, I'm trying to already, oh, here we go. All right, so involuntary bankruptcy was actually the first form of bankruptcy. There was no such thing as voluntary bankruptcy at the beginning. Involuntary bankruptcy was for creditors and merchants when they were owed a lot of money by someone that they started to suspect was not going to be able to pay all of them, to avoid preferential transfers and asset dissipation. All the creditors would get together and they'd put the merchant into bankruptcy and divide up the assets and collect as much as they could. And even up until the 1920s, 25% of all bankruptcies were involuntary. And at the time, the statistics were the recovery rates were much higher for creditors in involuntary systems. There's some literature on this that sort of laments the sort of decline of the involuntary because, the people making decisions, especially at companies, are generally equity holders, and bankruptcy extinguishes equity. And so a lot of organizations, companies delay filing bankruptcy way too long, long after the writing's on the wall, and dissipate a lot of assets and resources that could be used to pay creditors, sort of trying to keep it together. And so there's been a little bit of a movement to sort of find ways to sort of reinvigorate this because it does, have some important uses. And Congress did create it. Congress created it a long time ago. It has amended the statute occasionally. So Congress sort of wants this to be a remedy that is used. And we'll get into some of the reasons why people are pretty skittish about it. And the courts, that's largely because of the courts. The courts they treat these very seriously. And not without good reason, I mean, unlike filing a complaint, a civil action, there are very serious and immediate consequences to filing involuntary bankruptcy. Especially if you're doing it against a company, all sorts of financing agreements and insurance contracts. If you look at them, they have bankruptcy clauses, and most often it will say voluntary or involuntary that are triggered. And so if you put a company that has these into bankruptcy, unlike a civil action where it takes years for there to be any real consequences, this, a couple months, and these guys may find themselves in a lot of trouble, with sort of defaulted insurance agreements, and other financing arrangements. Um, and so, especially if you're talking about a public company, the market consequences could be quite severe for them. And so you can imagine, this could be abused. I mean, it wouldn't be hard to imagine even short sellers, putting people into bankruptcy to kill their stock price and take advantage of that. And, there's even one case, I can't remember the site, but where a court said, to a lawyer, you were given this very serious power to put someone in involuntary bankruptcy, and you've misused it. So I'm really going to whack you, because it's an extremely powerful tool. But it's necessary, as a lot of people here have experienced. A lot of debtors ignore subpoenas. They ignore discovery demands. They ignore complaints. They let things go to default. Assets disappear. Assets are transferred. Um, and, I certainly know in my practice, there's generally two piles. There are people who generally, are down on their luck and can't pay. And there are a lot of people who are choosing not to pay. And they're very skilled at avoiding state court remedies. And state courts, are overworked and, in my experience, not terribly sensitive to my problems with judgment debtors who are not showing up. And bankruptcy court is very different. This is all bankruptcy courts do. This is a federal jurisdiction, and there's a lot less messing around, because the consequences become quite severe. So, the question becomes, what do you do when ordinary collection remedies are not working, and you've got someone has the ability to pay? That's where we come to involuntary bankruptcy. That's what it's for. It is for, debtors, especially judgment debtors, who are playing fast and loose in state court. And as I said, only 0.5% of bankruptcies right now are involuntary. And part of the reason is bankruptcy lawyers are just very scared of them. Again, because largely of the literature, I think. If you just Google involuntary bankruptcy, these are the kind of headlines you get. Litigants beware. Use but with extreme caution. Be wary. Creditors be forewarned. And so, you sort of Google that and think, well, I don't want to sort of take that on. And they're complicated. As one court has said, they were assessing whether or not to award attorney's fees, as we'll get to, because if you try this and it doesn't work, very often you end up having to pay the other side's attorney's fees, and so those can be significant. And this is, one court was justifying the attorney's fees and saying, look, involuntary petitions are rare, and even experienced bankruptcy practitioners require more time to address the unusual substantive and procedural issues. So they are complicated, but but I think some of the literature is very overstated. This is a lawyer named William Barrett, who wrote an article in the Distressed Assets Central magazine, which I think is also an important sort of contribution to the literature. Mention involuntary bankruptcy to many in the credit industry, and you often get a sharp response. No way. Decisions that awarded punitive damages to debtors have received broad attention. But the truth is that joining an involuntary petition poses little risk to most commercial creditors. Little risk might be sort of a little bit too generous. I think it's probably somewhere in the middle. There is risk. There's more risk than there is in a traditional civil action. But it's nowhere near the risk that most of the headlines say, if you just Google this. So sort of from a 30,000 point view, if it's a single creditor situation with identifiable assets and existing collection, remedies that either haven't been pursued or are being successful, you're best to stay in state court. But if you see and you sort of can identify hidden assets, uh, definitely when there's multiple creditors, um, any kind of fraudulent transfers or preferential payments going on. And you've made some efforts to get discovery in state court and they're not working. That's when I think it's really worth considering this. And here's just a little decision tree that kind of reiterates some of those points. You don't actually need a judgment to initiate an involuntary bankruptcy. They're certainly preferred. It's going to make your life easier if you have a judgment, but it's not necessary. But sort of for the purposes of sort of deciding this, if you have a judgment, you're already sort of that step's done. If you don't have a judgment, it's probably worth getting one. Unless, as we'll talk about a little later, there's an urgency to it. Assets are really depleting, and you're going to be left completely out in the cold. But if you got a judgment, traditional collection efforts are failing. You've got evidence of asset dissipation. That there's more than one creditor. And this is where that's going to show the court that, look, we're doing a case right now where we've got 3 different judgments, our client, and we also know that he's got a substantial line of credit to another creditor that is not defaulted. So he's paying that creditor with our money or my client's money, and so that's sort of where state court's not really going to help you. You're not going to be able to get him to stop paying that loan through state court. Is there a legitimate bankruptcy purpose? And we'll talk more about that because that's a pretty nebulous term. But a lot of those sort of factors go into it. Are there multiple creditors? If there's multiple creditors and there's not enough money to go around, but there's some money, that's a legitimate bankruptcy purpose. Now we've reached the point where, look, this is what bankruptcy court is for. It is for when there's X amount of dollars and Y amount of creditors, and X is not going to satisfy Y entirely. But we need to have that done transparently, with a third party administering it, so that certain people aren't paid in full while other people to get nothing. So if you sort of can check those boxes, that's when you want to really talk to a lawyer or sort of think about doing this. So how do we do this? The requirements of an involuntary bankruptcy are actually not very onerous, despite the fact that it is an extremely powerful weapon. It doesn't take much. And you can do it either under Chapter 7, which is a liquidation, or Chapter 11, which is a reorganization. And sort of, that depends again on, whether you think after investigating it, is there enough money to pay everybody? More or less, actually, what this is Chapter 11 is going to be for larger organizations, Chapter 7 for sort of individuals or smaller companies. And so what are the requirements? There's actually only 2. You've got to have creditors whose qualifying claims aggregate only to $21,050. That's it. It's not a ton of money. And if there's less than 12 creditors, you only need 1. One creditor can do it as long as there's less than 12 creditors. If there's more than 12 creditors, you need to have 3. And I was actually in court the other day, in bankruptcy court, talking to the judge about a case. And the debtor had filed their own bankruptcy to stop a foreclosure. And the judge was dismissing it because he said it had been filed in bad faith. And I said, Your Honor, I got to tell you, my client isn't necessarily opposed to this bankruptcy. And his first response was, all right, well, get yourself a couple other creditors and do it involuntary. Which I thought was interesting that, again, despite some of the literature, courts, and this is a little bit by the judge, but they understand this is important sometimes. There are debtors who really play fast and loose with the courts. And when he'd already seen this debtor had been acting in bad faith, and he didn't really blink about that. So that's the number one is you got to have either 3 creditors or 1 creditor. And the second prong is the debtor is not generally paying their debts as they become due, which is a sort of little bit, again, it's kind of nebulous. And we'll talk a little bit exactly what that means. Going back to the claims, though. So you got to have claims aggregating to $20,050 or $21,050. What do the claims require? The claims require that they are free from what's called a bona fide dispute as to liability or amount. And this is essentially in law what's called the summary judgment standard. It just means, look, if there's a genuine issue of material fact that bears upon the debtor's liability or meritorious contention as to the application of law to the undisputed facts. If you've got a judgment that's unappealed, most courts, that's going to sort of clear the threshold, the hurdle. Some courts, will look into it a little deeper, but for the most part, if you've got a judgment, you can get through this pretty easily. But you don't even need a judgment. As I said before, sometimes there are circumstances where you can't wait to get a judgment. And then, most contract disputes, there is not a material issue of fact. You've got a signed contract, you've got a default letter, there's no payment. It's going to depend a little on the judge, but again, if there are circumstances that require you to do it before a judgment, certainly if you're in a loan or contract dispute, you're going to be able to probably prove that. The only other thing to watch out for is it's not just about liability in total, it's also the amount. So, if you've got a $100,000 judgment or $100,000 debt, but the debtor says, no, it's only $80,000, that can create something of a problem because unfortunately, what the courts generally say is if there's any dispute at all about the amount, even what the argument usually goes, look, let's say I have a $100,000 claim. The debtor disputes 90,000 of it. So the debtor accepts that there's 10,000. And then another guy's got another one, and so you get up to 21,000. The courts unfortunately have found that no, even if it's undisputed that you have claims aggregating 21,050, if there's any dispute about the amount, they're going to throw it out. So that's something to watch out for. Probably the harder one, or at least sort of the less clear one, is generally not paying their debts as they become due. That's done using what's called a totality of the circumstances test, which is kind of a fancy way the courts say of, look, it's up to the judge. It's in their discretion. The things they say they look at are the number and the amount of unpaid debts and default compared to current debts, the amount of delinquency, the length of time of delinquencies, the materiality of non-payment, the nature of the debtor's conduct in its financial affairs, and the number and dollar amounts of the debts in default. But again, you sort of read the cases and judges sort of grab at some of these and not at others. What they're ultimately trying to get at is this a legitimate case where you've got a debtor who should be in bankruptcy to sort of, distribute his assets? Or is this a situation where a creditor is using this as a kind of harassment technique to try to get their claim paid? And that's kind of, the more all the cases you read, that's kind of the central issue is this being used for this legitimate bankruptcy purpose that we're actually trying to enforce the rules of bankruptcy and do a fair, equitable distribution of assets? Or is one creditor, trying to force a settlement? Because, the other thing I will say is once you start this, you've got a lot of leverage. And, it's not wrong to use that leverage to settle your claim. But, in some ways, if that happens, great. If it doesn't happen and it gets to the court and the courts can make the decision on the motion to dismiss, and it looks like this is just a situation where you're trying to scare the debtor into paying your claim, that's where the courts sort of look to get rid of it. All that said, the failure to pay just one significant creditor can support a finding that the debtor is generally not paying its debts. So, notwithstanding all that sort of stuff above, if and there's a lot of cases, where creditors have $1 million claim they've been working on for years in state court. The debtor's not paying it. The debtor is paying their other sort of debts, even if they're just small, their cable debt and all that, but they're just refusing to pay this one. That can support a finding that the debtor is not generally paying their debts. Now, probably the biggest distinction here is that even if you have a valid petition, even if you meet all the requirements, you've got to, and it's a good case, the courts can still dismiss it. So unlike a traditional civil action where if you plead a claim and it's valid, the court has to accept it. Here they can still toss it. And they can toss it on one of two grounds: bad faith or what's called abstention. Um, and we'll talk a little bit about more what they mean by that. Bad faith, there's a lot of ink on this because courts, they really examine this, or they may examine it if they suspect, what we talked about before, which is that this is being used to sort of force the debtor into a settlement. And so they sort of, again, it's one of these totality of the circumstances tests. One thing they'll look at is the improper use test, they call it. And that's whether it was intended to obtain a disproportionate advantage for the petitioning creditor rather than to protect the creditors collectively. And this is a little bit confusing because it seems a little bit strange that you should have to think about other people's debts when you're sort of just trying to collect your debt. But that is just something to consider. Courts want to see that, if there are other creditors, and you can, and this is also just true. I mean, because once you get into bankruptcy court, the trustee is going to handle the payments, and so that's not that hard to prove just by reason of, look, we're in bankruptcy court. So if this is successful, we are not going to be paid at the expense of other people. That's just how the bankruptcy process works. Improper purpose is kind of similar, but that one they really looked at, was this motivated by ill will or a desire to harass? And sometimes, that will just go into the emails that have been sent between the creditor and the debtor. And if they sort of demonstrated some real animus, courts will sometimes take that into consideration, that this was sort of done, in anger. The objective test: would a reasonable person have filed this? That is not that hard to overcome. I mean, as long as you sort of do a thorough analysis and you've got a valid petition, a reasonable person or a reasonable attorney would say yes. But again, there are cases where, you see that it wasn't reasonable. It was motivated by just anger. See that sometimes even after divorce cases where husbands and wives will do this. And then finally, again, this totality of the circumstances test. Were the statutory requirements met? Did the creditor make a reasonable inquiry into the relevant facts? Was the filing used to create a tactical advantage and substitute for other debt collection procedures? Was the timing suspicious? Sometimes people will do this on the eve of trial, which courts sort of are very wary of. And did you have evidence of dissipation or for preferential payments? That's a big thing. Once you've got evidence of that, you're in a pretty good position because that's when this really becomes something that the courts will agree is valid. So that's bad faith. How do we show good faith? Well, make a thorough and genuine investigation of the facts. Check to make sure your client or this is not being done out of anger, but out of a genuine desire to get your claim paid in bankruptcy. And here's that quote we talked about a little bit. The proper purpose of a creditor filing an involuntary petition is to protect against other creditors obtaining a disproportionate share of the debtor's assets. So that's sort of the key phrase there. You're not trying to get a disproportionate share of the assets, but you're just trying to prevent others from doing that. And state court remedies. The fact, if you can show that you have pursued state court remedies without success, you filed a lawsuit, you tried to depose, you tried to get discovery, and the debtor's just blowing you off. That's an important thing to be able to show too. But they, again, some courts just really don't like these. So, although you have to show that you've sort of worked through state court to try to get this resolved, some courts then hit you even if you do that and say, well, if this is just the most recent battlefield in a long-running two-party dispute, they don't like that either. And, I mean, in some ways, of course, this is going to be the most recent battlefield. If you have done your duty and sort of pursued state court remedies and now you're in bankruptcy court, well, this is the new battlefield. Um, and this is where, again, this sort of two-party dispute comes up. For a long time, courts really would just dismiss two-party disputes. They would say, look, this is not a proper purpose of the bankruptcy court. If it's a two-party dispute, I'm sorry if you're having trouble in state court, but it's not our problem. That has sort of evolved over time, and courts have pointed out, well, look, Congress authorized one creditor to do this. So we can't say that two-party disputes are necessarily prohibited. That's inconsistent with the language of the statute. This is really a big problem in the Second Circuit and the Ninth Circuit, so sort of California, the West Coast, and New York and Connecticut. That for some reason, those two circuits really scrutinize petitions. They really don't like two-party disputes. So if you're outside the Second or Ninth Circuit, that's better. You can do them in the Ninth and Second, but just be aware that depending on the judge, they look at them a little bit more stringently. Abstention. And this is really just completely the judge's discretion. You've pled a perfectly valid petition, crossed all your T's, dotted all your I's. There's no bad faith. There's a good purpose. And the court still says, we're not going to do it because this is not in the best interest of the creditor or debtor, whatever that means. They will, they have listed out some of the factors that they will look at, including whether it's a two-party dispute, the economy and efficiency of administration, the availability of other case or forum to protect the interests of the parties, alternative means of achieving equitable distribution of assets, and the purpose for which the bankruptcy jurisdiction has been sought. Again, at the end of the day, this is really just the judge's discretion. And so like a lot of sort of litigation, it becomes a little bit more art than science. It's a lot of who the judge is. Just sort of the luck of that draw. Some judges are going to be are more willing to do this than others, it's a lot about, again, just making the judge comfortable that you're doing this with a genuine purpose. That this is not some guy or some company that you're just trying to beat up on, but that this is a recalcitrant debtor who has money to pay and is avoiding their creditors, and we've done everything we can. And at this point, they are hiding or dissipating assets that should be used under the law to pay our claim. And so whatever you have to do to sort of prove that, that's ultimately what you're trying to get through to the judge. This is kind of an interesting thing that's been coming around in the courts. And it's a little bit sort of lawyer nerd stuff, but it could, if this continues to develop, it would really open the doors to this remedy and make it a lot more available. And the issue is this: bankruptcy court relies on a lot of forms. When you initiate a voluntary petition, it's a form. And so unlike a civil action, where you file a complaint and you have to write down the reasons why you're entitled to relief, and the courts will examine that and say, well, your complaint isn't sufficient, you haven't alleged enough facts. In bankruptcy court, you have to use a form. And so there's been a number of cases in the last couple of years, especially in the Fifth Circuit in Texas and Mississippi, where creditors have initiated a bankruptcy using the form, and debtors have moved to dismiss and say this is, an improper purpose, they don't have a good petition. And the courts have rejected that attempt to dismiss the petition out of hand. They said, look, the creditors filled out the form. If that's not sufficient, then there's something wrong with the form. And this kind of sort of threw a lot of debtors into disarray because it suggested, wait a second, maybe this isn't as hard as it looked. There's been 5 cases in the last 5 years that have followed this sort of reasoning. And so it makes sense to me. In court, usually if you have to use a form, the form has to be assumed to be sufficient. You can't make me use a form and then say, no, the form's not good enough. So, I'll be watching this and sort of hopefully I can litigate it a little bit more to find out if we can sort of build that case law. Because if you could, that would really make this a lot easier because 50% of involuntary petitions are thrown out on motion to dismiss. Um, and so if these were essentially immune from motion to dismiss, um, it would make this a whole lot easier and would really sort of make this remedy something I think that creditors could use pretty frequently.
And did you say 50% are thrown out on a
Yeah,
motion to dismiss?
50%. Now, I
Wow.
will say that's not, I mean, unlike state court, collection cases where they really don't do motion to dismiss, 50% is it's not that high in federal court. So, I mean, for general, lawsuits of discrimination or, the Fair Credit Reporting Act, 50% is about average.
Oh,
50% of lawsuits get dismissed in federal court. So that sounds very high, and it is high, but
it,
it's about the same.
it struck me as high. We have
Yeah.
just a couple of minutes left.
Okay. All
So,
right. Let me start
and then
moving
we're gonna
faster here. Yeah.
make sure to post this on the website.
Good. All right,
So,
give me 2 more minutes. Okay, so
yep.
what happens after filing? File the petition, it's served. Either the debtor opposes it on motion to dismiss, and then the court hears that and they either grant it or dismiss it. Or sometimes the debtor will just default and the court will appoint a trustee and begin to administer assets. The courts can order the posting of a bond in the event that this thing ultimately gets thrown out and you have to pay attorney's fees. And that is something to watch. I mean, although I think the risks are overstated, they're real. I mean, getting hit for attorney's fees is pretty much non-existent in state court, as long as you have a more or less valid lawsuit. In involuntary bankruptcies, if it fails, in the Ninth and Second Circuit, again, you are presumed to have to pay the fees. In other courts, it's not presumed, but it's likely. Punitive damages, there's a lot of scare about that, but those are actually quite rare. Okay, so once you get into bankruptcy, trustees have a lot of power. They can collect real estate nationwide. They can pursue litigation against other debtors of the debtor and collect that money. They can recover fraudulent transfers, preferential payments, sometimes going back 10 years. And they conduct very serious depositions and examinations. And if you lie to the U.S. trustee, you're in a lot more trouble than if you lie to me in a deposition. So that's a big risk for the debtor. Another really cool thing is trustees can sometimes reach assets held in LLCs by debtors, which is not something you can do in state court unless you pierce the corporate veil. But there's not always, but there's a significant amount of law that because the trustee stands in the shoes of the debtor, the trustee can liquidate real property held in an LLC that doesn't actually belong to the debtor. And another thing that the debtor is now, again, looking at is bankruptcy fraud. If they think they're going to be able to play the same games in federal court that they did in state court, they're wrong. And people go to jail for bankruptcy fraud. No one's really going to jail for lying to me in a deposition, but people will go to jail if you lie to the U.S. trustee. I just did another little matrix here to sort of, think about whether you want to do this. If you've got hidden assets, multiple creditors, insider transfers, or discovery abuse, you got some plus points. Single creditor dispute or collectible assets have been identified, negative, add them up, see where you are. Strong candidate, proceed with caution, or probably stay in state court. And so that's about it. It's not a routine collection device, but I think it is an important one. I hope it starts getting used more because I do think it's overlooked and underused and is a very legitimate, valid remedy for a lot of people, on this call, in this situation. When you reach that stage where it looks like there's nothing left you can do, this might be the thing to do. So we can do some questions, or I really thank you for
Yeah.
having me. That's
Umberto
it.
Matz has a question. He says,
Sure.
how does the attorney initiating the involuntary bankruptcy get paid? From the bankruptcy estate or from the group of creditors that have banded together? Great
Yeah, I
question.
mean, good question. Yeah, so in this case, the attorney gets paid by the petitioning creditors.
By the creditors. Okay.
Yeah.
And so it's probably advantageous then, even though under 12 creditors, it's just takes one,
Yeah,
that one creditor would bear all the expense,
that's right.
as
Yeah.
opposed to over 12 creditors, you can share it.
Yeah.
Um,
And and if it's under 12, you can still use, you use as many creditors as you want always. That's just the minimum. But even if it's under 12, if you got two or three creditors or four creditors, yeah, then it's a lot cheaper to do it.
early on you said that there was, I believe, some hesitation, trepidation to file the involuntary bankruptcy, and I was wondering if that has come about because the focus is, there's a hot focus on consumer protection.
Yeah.
And is that still applicable to the commercial world?
I don't think so. I mean, certainly, yeah. I mean, if it's being done against a consumer, I think courts are going to look at that more skeptically. And so, but it would be. I can't imagine a situation where this would be useful to do against a consumer. Um, I mean, maybe there would be, but I think that. Uh, if I think consumers, in my experience, are if they're ignoring it and can't pay, they usually don't have sort of assets and property nationwide. So I think it would be. I don't have a ton of experience with that, so I can't say for sure. But no, I think lawyers are scared of it because really this is one of the few situations where they are going to be held probably if they screw it up, they're going to get in trouble personally. In most of the litigation world, even in federal court, if a lawyer screws up, the court's just going to get rid of it and sort of move on. But here, if you screw this up, the lawyer is going to get in trouble. The courts are going to sort of personally find them in bad faith, and it's going to hurt their reputation. I think that's really more of it.
Can I ask a
Another,
question?
yeah.
Yeah,
Oh, so sorry. It's better to ask it because otherwise I'll type it. It's too long and I'll make a lot of
yeah,
mistakes. So, so you said that the courts will frown upon creditors using the involuntary bankruptcy process to gain uh, an unfair advantage or leverage over the
yeah.
debtor. I mean, we're not doing this for charity.
No,
We're,
I
we're not doing
completely
this for the
agree.
societal good. We're doing
No,
this
yeah.
specifically to get paid.
Yeah,
So,
no, I completely agree. And I have I read those statements. I'm like, I mean, this seems kind of nuts. Like nobody's doing this for for the for the general good. This is not a charitable act where, we have a valid claim, we're trying to get paid. Um, and so I think what maybe it's a little inelegant the way they write it. Again, what I think what they mean is if you're essentially trying to extract a preferential payment for yourself, um, you know,
yes.
so in terms of which that's right. I mean, in some ways you are, but using the bankruptcy court to do that. And so again, I think what they're trying to say is if you're filing this just to get your claim satisfied, you're not trying to use the bankruptcy process for what it's for, which is to have an equal distribution of assets. You're just trying to scare the debtor into paying you, and that they don't like. And I totally agree with you. Look, your job is to get your claim paid. And what they would say is that's right, but if you're going to go into bankruptcy, if you're going to try to use bankruptcy, you have to accept going in. If it succeeds, which is my goal for it to succeed, it's going to be equal distribution for everybody.
So Austin, let me ask you. So let's say that I have three judgments against XYZ company.
Yeah.
Okay. And I come to you and it's like, hey, I want you to put these guys, I want you to
Yep.
start to initiate this involuntary bankruptcy process. And let's say that my judgments add up to $1 million.
Yeah.
So if I do that and I pay you your money up front and all of that, and you start to file obviously
Yeah.
you probably reach out to the debtor first. They
Yep.
ignore you just like they've ignored everybody else. And you use those three judgments to initiate that involuntary bankruptcy process.
Yep.
Now, soon after, the debtor comes forward and it's like, okay, I get it now. I've seen the light
Yep.
and I want this payment. I want to
Yep.
I want to pay out. Okay. And you negotiate that.
Yep.
Would the bankruptcy court come back to you or to us or to
Yep.
the creditors saying, no, you
No.
put the quarter in the jukebox, you got to do the whole dance now.
No, actually not. So and that does happen. I mean, because again,
Worse.
this does also send a message, hey, we are not screwing around anymore. And very often it gets resolved once you file it. And the courts are okay with that. If all the parties consent and you want to dismiss it voluntarily, no problem. The problem is sort of like if they call your bluff, and then you have to go to motion to dismiss and then explain to the court. But no, if you file it and the debtor comes to you and says, all right, I'll pay, you can voluntarily dismiss it. Everyone goes their separate way. The court's not going to have anything to do with it.
And I wouldn't have, you
Yeah.
would have to get other creditors that were not involved in that initial process
No.
to agree.
So again, no, you don't. So I mean, that's why in some ways, again, if they call your bluff and you go into the court, then the court's going to be like, I know what you were trying to do. If you do it successfully, that's one thing. If you don't do it successfully, then the court's going to sort of whack you.
So there's kind of like a point of no return.
Yeah, I mean, and they even write in a lot of the opinions say, if you're going to swat at the king, you better kill him. And they sort of use that language to be like, look, yeah, this is high risk, high reward here, guys.
That's interesting. We also had another question about antitrust concerns.
Okay.
Is there vulnerability to the creditors when they come together for antitrust
Oh.
violations?
That is a fascinating question. I've never heard someone ask that. I've never seen that, so I don't think it's ever been raised. If it were raised, generally there's going to be a safe harbor if this is being done pursuant to federal rules of procedure, which it is. But I'll tell you what, you could write a fascinating article about that for a law review, because that's right. I mean, you are sort of in some ways conspiring to do that. But no, you're the first person I've ever heard that raised that. I've never seen a court have to examine that. So I don't think that's a risk, but it's a fascinating question.
Greg Gardner, good question.
Yeah.
Thank you very much. Oh, this was wonderful. My Chicago native new affiliate member, Austin Smith
Yeah.
of Taroff and Taitz. So we knew it was going to be good because he's a Chicago native. Thank you very much.
Thank you all. This has been
This
great.
is just a very unique session, unique remedy. And for those of you that are keeping track, we have the next 20-minute talk. We have the law offices of Tim Sullivan, and Jeffrey Coburg is going to speak to us in August. You will get the notification, and he's going to talk about fraudulent remittances. So you'll get a notification on that. 1,000 thank yous to Austin and to Alex and those that asked questions and all of you who attended. This was great, and wishing you a great day, everybody, and see you in August.
Thanks, everybody.
Great job, Austin. Thank you.
Thanks a lot, guys. And if you have any
Thanks.
questions,
Take care.
reach out to me personally if you got any questions about this.
Take care.
Excellent.